Hello, my name is Wendy Mara of the Mara Law Elder and Family Law Center. And I'm going to be talking to you today about Medicaid planning. And so many people are very concerned about their assets if they should need long-term care. And in particular, I hear time and time again the concern, am I going to lose my home? Am I going to lose all of my savings if I have to enter a long-term care facility? So my goal today is to talk to you about some of the tools that are available so that you don't lose your home and you don't lose all of the assets that you've worked so hard to accumulate over the years. So Medicaid long-term care planning is key to protecting your assets. And should you or your spouse need to go into a long-term care facility. And so in Florida, the Department of Children and Families, DCF, determines eligibility for Medicaid for long-term care purposes. Medicaid laws are actually federal laws, but every state interprets those federal laws differently. So it's really important when you're talking about Medicaid long-term care that you speak with an attorney who is licensed in the state of Florida if you live in Florida. If you live in another state, then it's important to contact an attorney in that particular state in which you live, because the rules are different for each state, and assets that may be protected in one state may not be protected in another state. And different states allow different techniques for protecting your assets. So again, it's really important that you look for an attorney who's licensed in the state in which you reside. I am licensed in the state of Florida, so the information that I'm going to be giving you today is based on Florida's interpretation of Medicaid long-term care laws. So when DCF is determining whether or not you qualify for Medicaid, DCF looks at two different categories. They look at your income limits. There are income limit requirements, and then there's an asset limit requirement. And you need to qualify under both of those areas in order to be able to qualify for Medicaid long-term care. If the applicant does not qualify either in the income area or in asset limit area, then the applicant would not be able to have Medicaid long-term care unless the applicant engaged in some sort of Medicaid long-term care planning. So this is really important. Never fill out an application for Medicaid long-term care if you do not already meet the requirements, because you will be denied. With respect to applicants' income, the income must be under $2,328 per month, and that's for 2021. Every year that number changes, so this is the new number for 2021, $2,328 per month. The income for the spouse, which is called the community spouse, is unlimited. So as long as the applicant earns under that $2,328 per month, the spouse could be earning $10,000 a month, and it doesn't matter. The income of the spouse is unlimited. If the community spouse has no income or little income and is in need of support from the applicant, then the community spouse may qualify for what is called a spousal diversion, whereby some of the applicant's income is diverted, is put under the category of the community spouse. For 2021, the community spousal allowance minimum is $2,382. So that's the minimum amount that it's expected a spouse would need. And so if the spouse is earning just a part-time job and not earning much money, or earning no income at all, it would depend upon how much of that money can be diverted. And the minimum amount of money that a spouse is qualified to have in order to have that spousal diversion is the $2,382. However, that can increase all the way up to $3,259, but those are under special circumstances. And so that doesn't often happen, so you would need to get that specially approved. And again, those are one of the situations where it's really imperative that you speak with an attorney licensed in the state of Florida in order to be able to determine how you can go about obtaining, diverting income to the spouse and seeing if you qualify for that higher amount. So what do you do if the income for the applicant is over the allowed limit? Well, if you do nothing, you will not qualify. The applicant will not qualify for Medicaid. So if you do nothing, you get nothing. However, if you speak with an attorney, engage the services of an attorney can create for you a qualified income trust. And what the qualified income trust does is it's a legal way to allow you to have a higher income and still qualify for Medicaid. Now, not all states allow the Medicaid, the qualified income trust. The state of Florida does. And essentially what happens is there's what's called a personal allowance that each applicant is allowed to keep. So the applicant is allowed to keep $130 per month for personal expenses, going to get hair done, clothing, those sorts of things, $130 a month. And also the applicant is allowed to deduct the Medicare Part B that the applicant is paying. So $130 a month for personal expenses, Medicare Part B is deducted. The rest of the income must go to the skilled nursing facility. If you're needing a qualified income trust, that money would be deposited into the qualified income trust and then a check written out to the skilled nursing facility every month. So let's look at some real numbers here. If the amount of money left over after the $130 personal expense is deducted and Medicare Part B is deducted, let's say there's $2,000 remaining. And at this example I'm going to give you, there's no community spouse, so there's no spousal diversion. That $2,000, if that's all that's left over, then you qualify under the income limits and you don't need to worry about a qualified income trust. So, that $2,000 would go to the nursing home and then Medicaid will pick up whatever the difference is. So if the nursing home is $8,000 a month and you have $2,000 a month of income after your personal expenses and your Medicare Part B, then $8,000 minus 2 is $6,000 is what Medicaid is going to pick up. Now, if you earn $5,000 a month, again, you're going to deduct your $130 per month and your Medicare Part B. So let's say it's $5,000 per month after you've deducted your $130 per month personal expense and your Medicare Part B. That $5,000 is going to go into a qualified income trust. If you don't set that up, you don't qualify. And then a check would be written out every month to the skilled nursing facility in the amount of $5,000. Same scenario, it's $8,000 a month for the skilled nursing facility. $5,000 is coming from your income. The other $3,000 is coming from Medicaid. Again, if you're over the income limit and you don't have a qualified income trust, you will not qualify for Medicaid. With respect to asset limits, the assets for an applicant can't be more than $2,000. And there are some non-countable assets. So your personal property in your home, your household goods, your home itself is a non-countable asset, and a vehicle. So those are not countable. So that's not included in the $2,000. However, it does include other types of things such as any savings accounts, any checking accounts you may have, retirement accounts, depending upon if you are, your age, and if you're receiving your minimum distributions, your required minimum distributions. If you're receiving those required minimum distributions, then that's going to count as income instead of an asset. So the community spouse may have no more than $130,380 in assets for 2021. So a much higher asset limit for the community spouse. Oftentimes, because the community spouse is allowed a much greater amount of assets, it is not uncommon to transfer assets from the applicant to the spouse. That's not considered a gift if you're transferring to your spouse. And if the amount of money is under that community spousal limit of $130,380, then you qualify. As long as you keep your the amount of money that you have in your name under $2,000, you're going to qualify with respect to assets. And again, remember, their DCF is looking at assets separately from the income. So what are some things that can be done in order to qualify? Let's say you've done your transfer to a community spouse, but you still have too much money in assets. Well, there are strategies that can be used to reduce your assets. And again, this is something that you need to work with an attorney on. This is not something that you're going to be able to on your own do, because you want to make sure if you're doing any transfers of assets that it doesn't end up being considered a gift, in which case you're going to have a penalty. So some of the things that can be done when your assets are higher than the limit, even if you've done your transfer to a spouse or if you don't have a spouse, one of the techniques that people often use is spend down. And spend down is you're spending down your assets, but you can't just spend it on anything. It must be on expenses that are qualified. So if you have medical bills, you can use the assets that you have, cash that you have, and spend down your medical bills. Let's say you have your home, and there are things that need to be done on the house. Maybe a roof needs to be done. Maybe you have some electrical work that needs to be done. Any type of required expenses, maintenance on your home, those are allowable, and you can go ahead and do that. If you have an older vehicle and you're wanting to upgrade the vehicle, you can go ahead and purchase a new vehicle. If you have a newer vehicle and you have a loan on that vehicle, you can pay off the loan on that vehicle. If you have a mortgage, you can pay the mortgage off, and that's still that money that you use to pay off that mortgage is now in a non-countable asset. You can also purchase an irrevocable funeral contract. And the important thing with purchasing an irrevocable funeral contract is that it is irrevocable. So what that means is you can't decide you don't want that funeral contract and go back and get your money back, because then it's a countable asset. If you can go ahead and once you get qualified, go back to the funeral home and say you want your money, then that asset is available to you. Those funds are available to you, and they will count. You are also allowed, in addition to an irrevocable funeral contract, you are allowed a designated funeral account of up to $2,500. So you open up a new account, you designate that as a funeral account, and then it becomes non-countable. So there are other techniques also. If you have somebody who is providing care for you, then you can do a contract with that person, a personal services contract, and pay them in advance for the care that they will continue to give you. Now, if you're in a nursing home, your care is not going to be the same as if you are at home and needing more care at home. But still, even if you're in a nursing home, you may have somebody who's coming and bringing you to your doctor's appointments and getting your hair done, taking you shopping, going shopping for you, taking care of your bills, conferring with doctors regarding your care. So all of that counts. And so, money can be transferred, a lump sum payment to somebody who is caring for you. Many times this is done with family members. With any technique that you use, there are positives and negatives. And the positive is you're able to transfer this money to somebody who's taking care of you and providing them some sort of an income for the care that they're giving you, because many times people who are caring for a loved one are not able to work because of the care that they're giving, or not able to work as many hours. The downside is that money does need to be reported to the IRS. It's income, so taxes need to be paid on it. Again, the importance of conferring with an attorney in the state, who's licensed in the state in which you reside, is so very important. So I've talked a lot about different techniques that you can use if you are needing long-term care. And in the techniques that I've talked about are typically used for what's called crisis planning. And crisis planning is when you haven't planned in advance, and now you're up against the wall and you have to come up with some sort of way of protecting as much of your assets as you can. If you are watching this, then you're already thinking about Medicaid planning, and you may know that with Medicaid long-term care planning, there is what's called a 5-year look-back period. And what that means is if you're able to do some planning proactively and 5 years has passed, those assets for which you've done some planning don't even count. And that's really important, because the more money you have, the more difficult it is to protect that money and those assets with when you're doing crisis planning. And that's really where the proactive planning strategies are most helpful. And so, as I said, there's a 5-year look-back period, and that includes if you decided that you were going to gift. Let's say you weren't even thinking about Medicaid and you decided you were going to pay for college for your grandchild. You decided you were going to help your child with some business investment. Any funds that you give away in that manner is considered a gift, and there is a penalty for that. So the 5-year look-back period not only is looking at assets that you have planned to protect, and you've done your proactive planning, but anything that you may have gifted within the last 5 years. So that's something to think about. A tool that attorneys often use when they're helping clients with proactive planning is a Medicaid Asset Protection Trust. And what that does, you need to make sure that you are working with an attorney who's familiar with this type of trust. So it's not just a regular estate planning attorney. It's somebody who's familiar with Medicaid planning. And with the Medicaid Asset Protection Trust, you can transfer assets into that trust. And you can also transfer your home into that trust. And as long as 5 years has passed before you need any type of long-term care, those assets are never going to be counted because you don't own them. Now, that's the downside. With every type of technique, there's a plus side and there's a downside. And the downside is you agree to not have control over those assets. It's an irrevocable trust. You have a trustee other than yourself who's managing those assets. And you have somebody who's designated as a lifetime beneficiary. It's usually a child or other family member who can receive distributions during your lifetime. And so what sometimes happens is let's say you set up a Medicaid asset protection trust, you put your home in it, you put other assets in it that you knew that you were not going to need to access because because it's an irrevocable trust and you don't have access to it. You don't want to put all your money in there or all your assets. You put a portion of it that you know you've set aside enough for your needs, for vacations you may want, upkeep to your property, whatever it is that you want, and the other assets are in your Medicaid asset protection trust. If you did end up needing some of those funds, let's say instead of long-term care facility, you're in an assisted living facility, your lifetime beneficiary could access some of those assets and pay on your behalf. Can't give you the money directly because that's not your money, and then it defeats the entire purpose for making sure that you're qualified for Medicaid. But a lifetime beneficiary could receive a distribution and pay rent for an assisted living facility. They could receive a distribution and purchase a wheelchair for you or other types of things that you may need. So again, when you're thinking about doing long-term care planning, it's just so important to speak to an attorney. This is not something that you want to get some form trust off of the web and try to wing it, because then you could be ending up hurting yourself more than helping yourself, definitely. So you want to make sure you're speaking with somebody who knows what they're doing and is familiar in this area. And then some of the techniques that you use for crisis planning, you can also use for the proactive type of planning. So setting up an irrevocable funeral contract, setting up a funeral account, designated funeral account, and other types of techniques that really, depending upon your situation and what exactly you're hoping to accomplish and whether you have a spouse, there's lots of variables. So my suggestion is don't wait. Don't wait until you need long-term care. Now's the time to do it. And if you have waited, don't wait until the day before you're having to start paying for a skilled nursing facility. As much time as you can give an attorney to prepare, that gives more options. And so it has been my pleasure speaking to you today about Medicaid planning, both crisis planning and proactive planning. And it would be my pleasure to have me and my staff meet you. We do offer a free half-hour consultation for Medicaid planning. And, if you're interested, please give us a call at 386-672-8081. Thank you and have a wonderful day.